Part 1, Introduction and Making Preparations in Advance. Supporting individuals with mental health issues poses unique challenges in our society. The purpose of this video is to educate and provide guidance to individuals living with mental illness, to caregivers, and to the family and friends of loved ones. You are not alone in determining how best to help a person with a mental illness. This video is designed to encourage you to not be ashamed that you or your loved one has a mental illness, and to guide you to take the needed steps to seek help. In general, our society is proactive in caring for a physical illness, but we are generally much more hesitant with treatment for a mental health illness, which may be less obvious or masked. For example, if someone is doing well in their work or education, we often confuse the person's otherwise successful performance as not needing help with mental health issues. Please note, this video is entirely focused on adults age 18 and older. What happens when you are incapable, either due to a mental illness or other condition, to make mental health or physical health decisions for yourself? What can a person do now to be sure that your wishes are honored when you are incapable of making mental health or physical health decisions for yourself? If we act when we have the capacity to create an advance directive, that action greatly reduces the likelihood of a complete stranger, a judge, a guardian, or a mental health treatment guardian making decisions for us. What is an advance psychiatric directive? It is a legal document that tells your doctor what treatment you want to improve your thinking and behavior when you do not have the ability to understand that you are ill or understand the purpose of the treatment that is recommended, or you are unable to communicate what treatment you want, or you cannot understand the risks and benefits of the treatment. Your psychiatric advance directive tells a doctor whom you want to make mental health decisions for you if you cannot make them. The treatment requested is infeasible or unavailable. Infeasible, for example, is when you request a specific type of treatment, but there are no resources to pay for it. An example of unavailable means that treatment is not offered at the facility or a nearby facility. The facility or provider is not licensed or authorized to provide the treatment required, or the treatment conflicts with other applicable law. For example, other laws concerned with your safety or someone else's safety may not allow your request to be honored. The legal document that allows us to direct our own care is called an advance directive. There are two types of advance directives: a psychiatric advance directive and a healthcare advance directive. The advance directive must be created while you have the capacity to understand what you are saying. Capacity has a different meaning, depending on circumstances based on specific laws. But it means you understand the reason why treatment may be necessary, and you understand the benefits, risks, and drawbacks of treatment, and alternatives to mental health treatment, such as no treatment at all. It doesn't take much to create a psychiatric advance directive to make your wishes known, and it does not require a lawyer. No one can force or threaten you to create a psychiatric advance directive. It is your choice. All you need is a pen, paper, and a witness, or a computer, printer, pen, and witness. Write Psychiatric Advance Directive at the top of the page. Below it, write the date. Now write, I am willing to take this treatment if I cannot make decisions for myself, and list them. Or you can write, I want my sister to make mental health decisions for me. Write her name and phone number down. You can do both. Have someone who is 18 years old or older who knows you watch you sign it. But it cannot be your healthcare provider or the person who will be making decisions for you. Then that person writes, I have known the signer since blank or whatever date, and that she seems capable of making this legal document. Have the witness sign it and give her phone number. Now take the document to your doctor and ask that it be filed in your medical records. There is no need for a notary, although it may help. You need someone who knows you and can say that you have capacity to understand what you are signing. The Guardianship, Advance Directive, and Mental Health Treatment Guardian laws were created to protect our right of self-determination and to protect the health and safety of a person when they lack the capacity to make decisions for their own well-being. This video will help you to understand the law and to give you a framework for how to have your voice heard under all circumstances. There is a set of laws that govern psychiatric treatment and another set that governs physical treatment. The purpose of this video is to encourage you to make wise decisions for your future well-being, or guide your loved one as to what treatment you would want in the event your agent, mental health treatment guardian, or guardian must make for you. The best outcome for everyone is to create an advance directive for psychiatric and health decision-making while they have the capacity to create the document, before their lives are in crisis. It not only benefits them, but also their family, since their express needs are known, and the family knows they are following what their loved one would want them to do. An advance directive is only used when the adult cannot give informed consent, and should not be used to force the adult when they can otherwise make their own decisions. You should be aware that the authority of other surrogate decision makers under the New Mexico Healthcare Decisions Act does not include mental health treatment decisions. This is where a family member or someone who knows the patient's personal values can make other medical decisions for the adult. It is quite important that there be encouragement, caregiving, support, and follow-up when the person does not voluntarily seek the help needed, or when they do not voluntarily continue their medication, treatment, and/or therapy. As a rare last resort, when all efforts at encouragement fail, there are options when forcible efforts are required to get them assistance for their well-being. A key theme of this video is the importance of balancing the adult's rights to determine their own path of recovery and the need to provide for their well-being and for the safety of others. We are all allowed to exercise bad judgment, but we are not allowed to endanger others or ourselves, whether we have a mental illness or not. This video is presented in the following 5 parts. The first part you are reviewing is the introduction and regarding making preparations in advance. Part 2, understanding mental illness. Part 3, which type of guardianship is needed? Part 4, role of the guardian and treatment guardian. Part 5, in the event the individual you are assisting is already incapacitated and cannot make or communicate decisions for their own well-being, an advance directive is not available. Appointment by the court of a mental health treatment guardian may be the only option available to get them assistance for their well-being. As with advance directives, this option should not be used as a tool of compliance to force the adult who can otherwise make their own treatment decisions but is non-compliant. The court will have a hearing requiring clear and convincing evidence that the adult is not capable of making his own treatment decisions under Section 43(1)15. A mental health treatment guardian can be appointed for either outpatient or, more frequently, for inpatient care at a mental health facility. A mental health professional or developmental disabilities professional or physician must have evaluated the person living with a mental illness and must testify in court. Be aware that one cannot presume that the adult does not have capacity solely based on commitment for mental health treatment or while awaiting commitment. The treatment guardian may seek an enforcement order from the court for outpatient clients who refuse to comply with treatment guardian's decisions, and the order may authorize a peace officer to take the person into custody for transport to an evaluation facility and may authorize forcible administration of treatment. When no one else is available, trained mental health treatment guardians are available from NAMI, the National Alliance for Mental Illness of New Mexico, at 800-953-6745, or from the Forensic Intervention Consortium of Doña Ana County, FIC-DAC, for the entire southern part of New Mexico at 575-523-8015. In addition to the appointment by the court of a mental health treatment guardian who makes decisions about treatment if the person's need is only about mental health, the adult may also need a decision maker related to other needs such as where he will live, benefits and services, financial, other medical treatment, and other matters. Please see Part 3 of this video on which type of guardianship is needed, and the other 2 training videos available from the NMDDPC Guardianship Program related to guardianship and conservatorship, and alternatives to guardianship. You may review these other 2 videos from the website at www.nmddpc.com/guardianship_program, or request a DVD by calling the phone number 505-476-7372, or call toll-free 888-779-6183. Court-appointed guardianship should be a last resort. Protecting the adult's civil rights and self-determination requires everyone to first consider alternatives of the least restrictive means available. There's always a presumption of capacity, which can only be overcome with clear and convincing evidence of incapacity, with incapacity being a legal, not a medical determination. If guardianship is required, the preference is for a limited level of guardianship to meet the required decision-making, rather than full plenary guardianship. New Mexico law, however, allows for administering medication on an emergency basis without the person's consent, pending appointment of a treatment guardian, if the physician believes the administration of psychotropic medication is necessary to protect the client from serious harm. The physician must place in the client's medical records an explanation of the emergency and why no less drastic treatment will protect the client from serious harm. The court may issue an order permitting continuing psychotropic medication until a treatment guardian is appointed. When the above options of advance directive nor the appointment by the court of a mental health treatment guardian are successful, a final option is commitment by the court, which involves detaining and transporting a person for emergency mental health evaluation and care. This ultimate occurrence is only if the adult is more likely than not in the near future presenting a likelihood of serious harm to oneself, which includes grave passive neglect, or to others, and that immediate detention is necessary to prevent such harm. Reference Chapter 43, Commitment Procedures, Article 1. In summary to this introductory section, we hope this video will help you understand available options and to seek assistance in supporting individuals coping with mental health issues. The next part of this video is intended to help with understanding mental illness.